So, hello everyone. Welcome to the second NAMC workshop for 2024. So, as Steven said, today we are going to talk about Joshi v. Myers Petroleum, which is the case for this year. And we're going to be talking a little bit about the case itself, doing a brief overview and doing an overview of some of the cases within the tables of authorities, not all of them, just to um, get everyone's juices flowing and prepare for a great season. So the focus of today's workshop, as Stephen sort of indicated, isn't so much to have a complete and totally holistic guide of every case in the table of authorities, or the cases within those cases, but more so to focus on the issues themselves. What are we talking about in this case? How does Article 3 standing work? How does judicial recusal work? And what might be some good resources to think about that? So we have um, four items on the docket today. The first is we're going to do a very brief overview of Joshi v. Myers Petroleum itself. Then the wonderful Stephen King is going to be talking about Article 3 standing. Then I will do a little bit on judicial recusal. And then if anyone has any questions, um, we will take those questions. Okay, so yes. So the first item on the agenda today is that we're going to do a very brief overview of the case itself. Okay, so the facts of the case are that we have our petitioner, Shreya Joshi, who lives in Silliman County, New Stork, which is an area that is very prone to wildfires. Joshi is concerned with the fact that she may lose her home to a wildfire in the near future, and there are statistics to demonstrate that it is evident that a fire will, at the very least, likely reach her home within the coming years. And so, as a result, under the Weather Action, Resilience, and Mitigation Claims Act, also known as the Warm Claims Act, for the purposes of this case, she has brought the case at bar against three very large producers of fossil fuels, essentially saying that because they have contributed to climate change, which itself contributes to the proliferation of wildfires, that they ought to. That they have injured her in some way that they have to ameliorate. Okay, so a little background on what the Warm Claims Act is and how it works is it allows any injured party who is injured by some result of climate change to sue emitters of greenhouse gases if they fail to reduce their emissions as the act stipulates. So this case was brought before the United States District Court for the Southern District of New Stork, and the judge entered a summary judgment against Shreya Joshi. And for the Article 2 people, it is important to note that the presiding judge has made various comments in past years, both in favor of oil production and in opposition to the Warm Claims Act itself or drafts of it, both in public and private settings. And then, yes, so this is how we get our two questions. So for anyone who is doing issue one, the question is whether or not a private party has Article 3 standing to sue the fossil fuel producers. And for anyone who is tackling issue two, your question is whether or not Judge Moss, who was the presiding judge at the district level, was required to disqualify or recuse himself under 28 United States Code Section 455, Part A. And I believe with that, Stephen, take it away, please.
So yeah, on to this issue one about Article 3 standing. Before I get into standing specifically, I kind of want to set you guys the scene. So let's do story time. Let's say I'm at a restaurant and I'm enjoying my meal with my friend when all of a sudden that friend begins to feel sick. Turns out that the dish was cross-contaminated with peanuts and they are definitely allergic to peanuts. It's just not a pleasant situation to be with them. My friend has to go to the hospital, and this entire evening has just caused me so much stress. And the night is so bad that I kind of want to punish the restaurant and get some form of compensation from it. So the central question here is can I sue? This is meant to say the restaurant. And I think we can all understand that reasonably, no, I cannot sue the restaurant just because my friend was sick, though my friend would be able to sue the restaurant. The question, though, is why is it that some people can sue for certain harms that are done and other people can't sue that for harms that are done? Or what the prospective harm is. Could I sue a restaurant that has a wet spot on the floor that doesn't have a any sign marking the fact that there is a hazardous area and people could slip on it, even if I don't slip on it and I don't see anybody slip on it? And can I prevent somebody from doing something that I think will harm me before it even has a chance to happen? And this is ultimately a question of standing. Standing or locus standi is the capacity of a party to bring a lawsuit in court. Generally speaking, the person suing another party must demonstrate that they are suffering from some type of harm, and the person being sued must be responsible for that harm. I can sue a restaurant if the restaurant's the one that gave me something I'm allergic to, but I might not be able to sue the restaurant if the restaurant did their due diligence and attempted to protect against that. But it turns out one of the companies that they contracted food with lied to the restaurant and actually did have cross-contamination in their factory when they initially promised that they didn't. You kind of have to go over the party that's really responsible for the harm being done. The purpose of standing is ultimately to prevent frivolous litigation, to ensure that our judicial system works smoothly, that we aren't clunking it up with a lot of cases, and that the economic harms that are being addressed in a way that isn't too punishing or too great. The redress should fit the harm inflicted.
Now, Article 3 of the Constitution introduces an interesting kind of complication of what standing means. Because we're all Americans, we're all U.S. citizens, and there can be certain laws passed that theoretically have an impact on our lives. And so if standing just requires, harm done to us, you have to question what that really looks like when we're talking about a congressional law that arguably harms us, and whether we can sue the government to attempt to prevent that. Now, this is Article 3 of the Constitution, specifically the case in controversy clause, and it kind of extends to what exactly the judiciary that's now going to be set up by the Constitution will be able to do. A judicial power shall extend to all cases and law and equity arising under this Constitution, the laws of the United States and treaties made of, or which shall be made under their authority. And this is the important part. To all cases affecting ambassadors, other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens, or subjects. Now, two really important words here are kind of cases and controversy, and that compares all throughout this. Cases affecting ambassadors, all cases of admiralty and maritime jurisdiction, controversies to which the U.S. shall be a party, controversies, controversies. And the important part of the phrases cases and controversy is they're kind of inherently limiting what the judiciary is actually supposed to settle. They don't talk about any political issue. They don't settle every single disagreement. Instead, they specifically address cases and controversies, which are just these broader terms to kind of reference the fact that the court is really focusing on legal cases, legal decisions, and kind of legal conflicts between two parties with standing. Now, this was born out of the separation of power, which is kind of this recognition that we don't want the judiciary to be used as a tool to stop actions from the executive or legislature, right? We don't want the courts to be able to come in because I sued the federal government and Congress because I don't like a Congress law passed, and the court to be able to stop that. So standing is really important in order to ensure that we maintain that separation of powers. A bit into the history of Article 3 standing specifically. Some foundational cases are Fairchild versus Hughes in 1922 and Frothingham versus Mellon in 1923. These are kind of the first real cases that really discuss standing. Fairchild is about the legality of the approval of the 19th Amendment, the potential law that would fine those that denied someone the right to vote on the basis of gender. Basically, this law had not been passed yet, but somebody sued Congress about the method through which the 19th Amendment, which gave women the right to vote, expanded women's suffrage, was approved. He had a problem with that. He had a problem with attempting to enforce that. He was a general citizen of the United States, and he attempted to sue the government in order to prevent it. And he was, of course, prevented from doing so because he did lack standing. Far from him is a similar case. This time it's about a grant program to distribute money to states to decrease maternal mortality rates. Once again, the litigant claims his taxpayer money was being used to fund this program that he disagreed with, that's some form of financial harm for him. And once again, his case was dismissed because he did not have Article 3 standing.
And increased interestingly, in FCC versus Standards radio station, the interested party there was this radio station that thought that the government was giving preferential treatment to certain radio stations that was adversely harming them. This was interest, however, was still litigated through a specific economic injury recognized through the Communications Act of 1934. Much like the law, actually, in the case I brought to that you will be arguing, the government passed a law that specifically stated that people have the right to sue when they suffer this kind of economic harm. So it was still this example of the people only having the right to sue the government or sue another party when the economic interest being asserted is specifically recognized by some form of legal statute or rule. Over time, though, this begins to evolve. Beginning in the 50s and 60s, there are a couple of environmental court cases that come up that really consider other types of harm outside of economic harm. And while the government is not initially willing to recognize those harms, the United States versus students challenging regulatory action procedures is really the high mark in which the government is really permissive with litigation. There's this surcharge proposed on railroad use, and this environmental group will claims that they will suffer economic, recreational, and aesthetic harm directly from the result of adverse environmental impact on the railroad freight structure. It was an argument that it would be more expensive to access certain forms of public nature, and that the economic impact the surcharge on railroad use would have on different companies would cause them to recycle less and produce more waste, which would be economically harmful or environmentally harmful. And the important thing is, even though it is arguably a bit further removed from the actual actions of the government itself, and even though we're talking about environmental harm and aesthetic harm instead of economic harm, the court actually rules in favor of students challenging regulatory action agency procedures. It's just this massive shift away from the court's traditional doctrine that represents this growing expansion, first from rights specifically mentioned in law to eventually economic injury to, broadly speaking, kind of other types of possible harm. After this, however, the court begins to roll back its sort of leniency when it comes to determining standing. They begin to pay more attention to what are the actual economic harms that are being suffered from and really focus on that. They pay attention to how specific the harm is, whether it's being distributed across a wide group of people or across the entire country, or whether it's really targeting one or two people. Which really leads to this quote at here that Article 3 requires a party who invokes the court's authority to show that he personally has suffered some actual or threatened injury as a result of punitively illegal conduct of the defendant, and that injury fairly can be traced to the challenged action and likely to be redressed by a favorable decision. This case decided in 1982 is just kind of a culmination of this constant shifting among legal arguments and this growing evolution of how the court thinks about standing. The important part, though, and where the story really begins for you guys, is Lujan versus Defenders of Wildlife, decided in 1992. This is the first case that really sets out specifically what it means to have standing under Article 3 of the US Constitution. It points out that there must be either a real harm suffered or like a serious chance of real harm suffered. That's not simple possible to use simple possibilities of future harm in order to sue someone. It highlights the fact that the person's injury must be genuinely related to the actions of the party being sued. And it discusses that the availability that the court has to kind of readdress those harms really will readdress those harms. That you can't sue someone for something if suing someone for their money won't actually change the harm that you suffered. With that being said, that's kind of just this broad overview of this complex issue, just so you have a better idea of what exactly standing means. And I think we can turn it over to issue two.
All right. Thank you, Stephen. That was just an absolutely fantastic review of standing. Um, so that is the issue for the issue one, folks. For the issue two, folks, we're going to be talking a little bit today about judicial recusal and how it works and some of the cases around it. So the question for the issue two, folks, is whether or not Judge Moss, who was the judge on the for the district court that originally granted summary judgment for the case, whether or not he was required to disqualify himself under 28 United States Code Section 455A. And just a little reminder here that we have limited what is to be considered in this case to exclusively Section A of or Part A of Section 455. So you don't need to worry about any of the rest of the statute. So for anyone who would like a refresher, this is the entirety of the central law on which the issue hinges. It's just this one sentence. And this is Appendix B. So for anyone who would like to access this at any time, all you have to do is open up the case bar and scroll all the way down to Appendix B, and it will be right here. So Section 455 speaks to the disqualification or the recusal of a justice, judge, or magistrate. And all it says is that, quote, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. So this is not so much a constitutional issue as Stevens is, and as Article 3 standing is. There isn't so much needing to delve into the Constitution. It's more all based on statute, mostly Section 455, but also a few other laws that we're going to talk about. Okay, so story time again, but a little different this time. So let's say that you're at the same restaurant, you're enjoying the same meal with the same friend, and they start to feel sick again. And it turns out that their dish once again was cross-contaminated with peanuts. But in this variation of the story, let's say that we know that it was due to an error by the restaurant or some sort of negligence. We know that they said there were no peanuts in this dish on the menu, and that if you have a peanut allergy, you can have it. But due to cross-contamination, your friend ends up having an allergic reaction anyway. Now, if the friend who suffered the allergic reaction sues the restaurant, who would have Article 3 standing, as Stephen wonderfully pointed out for us, let's say that then that issue goes to trial, and it happens that the presiding judge who is going to determine this case is the CEO of the chain of restaurants where this incident occurred, and he just so happens to be a judge in his free time. That would be an instance where, as the law says, there is a reasonable person would think that the judge might not be so impartial in that case. So, in talking about judicial recusal or disqualification and its place in this case, first I wanted to go over a few of the cases from the table of authorities, not all of them, just some of them that might be serve to show a few different aspects of recusal, I suppose you could say. And then after that, we are going to go over a few other items that may help gain a more holistic understanding of how judicial recusal works. Okay, Liljeberg v. Health Services Acquired Corporation. I've also included up here in the top right corner both the year, but also the court in which this was decided for each of the cases, because for just a reminder for all of you, what level the court case was decided at, be it district, appellate, or supreme, changes how controlling the opinion is. If something was decided by the Supreme Court, it is binding for lower courts. But if something was determined by a circuit court, it's more so suggestive. Something that circuits should probably look at and probably follow, but they don't have to follow it as they do with Supreme Court cases. And that's just something to keep in mind sometimes. So I've noted that up here in the top right, for all of you. So this is a case from 1988 where essentially what happened is there was a dispute over ownership of a hospital. And the judge, who was Judge Collins, ruled in favor of Lilleberg, and this is a case that did not have a jury, so it was solely decided by the judge, sort of like the case at bar. It was later found out by Health Services Corporation, which was the party that was ruled against, that Collins was on the board of trustees of a certain university which had a transaction that involved Lilleberg, and so they sought to vacate the judgment under Section 455, saying that he wasn't partial or he wasn't impartial, and that a reasonable person would think that he would have bias in this case. And so the appeals court that heard this case found that they did not have any evidence that Collins was aware that there was any sort of bias, but even still, they vacated the judgment, or essentially they threw out what he had said because of the quote appearance of impropriety. So what this course or what this case talks about is that essentially the holding can be summarized as the disqualification or the recusal of a judge is appropriate when you reasonably should have known that a situation created an appearance of impropriety or of being biased, even if you were not actually, if the judge was not actually aware of the details of the situation. So that is one factor that can determine whether or not a judge should recuse themselves. So that is sort of an overview of this case. One other one that I wanted to talk about is the United States versus Cooley. You will note that this was decided in the 10th Circuit. So in this case, a few protesters, some abortion protesters in Kansas were convicted for attempting to obstruct access to a clinic. And they appealed this case and they raised issues about the jury not being instructed properly, and the indictment not being properly obtained, and that different legal processes had not been followed correctly, and that the judge was biased. And most of these claims did not pass. But the appellate court did find that the district judge should have disqualified himself, again, under Section 455A, again, to the appearance of impartiality. And because of that, the convictions were vacated, and the case was retried with a new judge. In Reberry, this one is a little bit complicated, which is why I wanted to talk about it with all of you. So this is a case from the DC Circuit. So what happened here is that the defendant petitioned for a writ of mandamus, and we're going to talk about what that is in just a little bit. But the defendant petitioned for a writ of mandamus, and essentially what happened is the judge found, or the judge refused to recuse himself, because the defendant failed to show what is referred to as a clear and indisputable entitlement of such relief, under the appearance of impartiality standard that we talked about in Lilleberg. So there are a few important things to note about this first point. The first is the return of the standard of the appearance of impartiality, again, that being an important standard, an important sort of phrase to remember. And then the other thing to note is the fact that the district judge refused to recuse himself. And that's important because it reflects the fact that generally recusal works in the United States by the judge choosing to recuse themselves. It's not that every possible conflict of interest that a judge might have goes before some sort of tribunal that decides whether or not the judge is biased. The judge originally chooses whether or not they wish to recuse themselves. If they choose not to, and um, the one of the parties in the case feels that they should have, they can then question that under the statute in a higher court. So that's what most of these cases are about. So yes. So the writ of mandamus is essentially a court order that requires a government official to properly fulfill their official duties. A writ of mandamus essentially can force a judge to recuse themselves, sort of by the process that I just outlined earlier. If a judge chooses not to recuse themselves, but you think they should, you can file or petition for a writ of mandamus, it is called. The motion, the writ of mandamus for the recusal, was based on the judge's extrajudicial remarks about various aspects of government that we don't need to get into today. Those are all in the case. But they fell outside of the judge's time on the bench. They weren't when he was acting in an official capacity. They were when the judge was off duty, you can say. And so, though that could be potentially thought of as violating judicial conduct rules, and we'll go into that a little bit later, it did not necessarily establish bias under Section 455. So, this last point here, the judge's views partially informed by media reports about the jurors. It was deemed non-disqualifying as it did not necessarily suggest a fixed opinion about the defendant. So just because the judge is exposed to something or says something outside of the courtroom does not necessarily mean that they are biased under existing case law by the time that this case was decided. Okay, so those are some of the most important, or not necessarily most important, those are some of the cases from the table of authorities and some quick reviews of them. There are other things that you may want to know. Before I get into any of these, I want to note that um, most of this stuff cannot be cited per se in your arguments because they fall outside of the case and the resources used in the case, but they can be thought of or they can be explored in order to kind of understand judicial recusal and how it works in the United States. So, first is Federal Rule of Civil Procedure 60B, sometimes referred to in the case at bar as just Rule 60 or Rule 60B. And what that says is, quote, on the grounds for relief from a final judgment order or proceeding, on motion and just terms, the court may relieve a party or its legal representative from a final judgment order or proceeding for the following reasons. It lists out a couple, and then in Section 6, which is the specific section that is referenced in this case, it says that any other sort of reasonable reason that the judgment can be vacated can also be used for appeal. So essentially, all this federal rule does is it, if a judge is found to be biased, in this case, or in any case, this is the federal rule under which the judgment that they made can be vacated. So under 455, I can say the judge was not reasonably impartial. And then because of that, under Federal Rule of Civil Procedure 60, Section B, I can say this judgment that they made ought to be vacated. So other materials that you may want to use for a general overview of judicial recusal. Again, note that these can't be cited per se, but they are just something that you may wish to know about. The first is a court case, Caperton versus A.T. Massey, which is a Supreme Court case from 2009. This was a case where the person who was ruled against, how do you say, or person involved in the case was a very wealthy person who had donated to the campaign of a judge who had heard the case at a lower level. So essentially, that was to say that even the point of this case was pretty much to rule out or to say that even if a judge does not have a direct monetary interest in a case, just as Judge Moss, as it is stated in a footnote, does not have a direct monetary benefit. In this case, they can still be requested to recuse themselves if they have like a general other non-monetary reason that they would probably be biased if the facts of the case are given to a likely bias. So that might be something if you want to do any additional reading and brush up. Another statute to look at is a 20 United States Code section 144. So 144 talks a little bit more about a judicial recusal and a few other situations in which it can happen. Again, these aren't things that you would want to use in your arguments because they can't be cited for that purpose, but what they can do is they can give you an idea of the sort of situations where judicial recusal is requested or granted, and then that can maybe teach you a way of thinking that you can then sort of incorporate into the materials that we have given you. One final similar resource that I wanted to point out for all of you is that there is a official code of judicial conduct that is available online. And there is one particular rule that also speaks about impartiality for judges, which is for section, or it's called Canon 3, Section A, Part 1. That also speaks a little bit more about the need to be impartial and what constitutes impartiality and what may constitute some form of bias. So that is my presentation. And I suppose with that, thank you, everyone. And we are now moving on to the Q&A.
This can be any questions about either what we talked about today, or if you have any other general just concerns about either the brief writing side of things, the oral argument side of things, different cases, and different tournaments, anything like that, just let us know. But yeah.
Yes, Ruth.
Hi, so I wanted to start off by saying thank you so much for having this workshop. I think it's really helpful. My question is in regard to precedent and the value that it has in terms of like when you are presenting it in an oral argument. So when it is a plurality opinion, I'm pretty sure that it's persuasive to the court, like the courts below do not have to follow it. That precedent is not binding, correct?
Yes. So if this current case that or the case at bar rather, it's been decided by Judge Moss at the district level and is now at the appellate level. So at the appellate level, if a Supreme Court case is proves relevant, that is binding. But as you say, if there are for any other circuit court cases, especially if there are many circuit court cases that agree with each other, those would be counted as persuasive. So there are certainly cases that you would want to bring up in your arguments, and their precedent is something that the court would find persuasive and probably want to follow, but they're just not quite as legally binding as a Supreme Court case, and that just might be a good thing to keep in the back of your head. Thank you.
Okay, that makes sense. Thank you.
Did you say that the Federal Rule of Civil Procedure, like Section 60B or whatever, that is that able to be cited? Is that referred to in the like case at hand, or is that just another of those sources to consider, but that we can't actually cite?
Uh, for like just citation purposes, just keep in mind that you probably should indirectly cite or quote from any statute outside of how it's mentioned in the case, just to be safe. You can obviously take forward legal principles. You can, of course, look into any of those other statutes, but try to, because it's in the case, try to specifically if you're going to quote it or refer to it, don't refer to like a section of it that isn't in the case at bar because, as Ben mentioned earlier, it's a decently long section that has several different modes through which judicial recusal is possible, and the instant case doesn't mention all of them or even most.
Yes. Thank you for that. Yes. So just to be very clear, if you are going to cite it specifically, you should reference not anything within the Federal Rule of Civil Procedure 60, but particularly Section B, subsection 6.
Got it. Thank you.
Thank you.
Yeah, thank you for spending your Saturday with us. We really appreciate you taking your weekend to spend a few minutes with us to talk about moot court. If you have any, this is just credits for the website. If you have any questions, you can always reach out to us either through the NAMC web email. Us board members are always checking it, so one of us will see it eventually, or just in general. For this slide, we will be uploading a recording of this presentation onto our website in the coming days. So you'll be able to access it on our website and our YouTube channel through there. Other than that, though, I hope you have a wonderful weekend.
All right. Thank you so much for coming, everyone. And thank you, Stephen, for a wonderful discussion of Article 3 standing.